Hello, everyone, and welcome to Thursdays Live with Chug. Each week, we cover pressing topics that matter to you and your business. My name is Arianna Gonzalez, and I'm the Client Services Manager here at Chug Attorneys and CPAs. Please join me in welcoming partner and attorney Min Kim from our Edison, New Jersey office. Hi there, Min, and welcome.
Hi, Ariana. Thanks for having me here today.
So in today's session, we'll be providing you with valuable insights into the updated PERM form, so stay tuned for tips to guide you through the process of navigating the new system. Just a quick disclaimer before we begin, I'd like to remind you all that we are live on YouTube, LinkedIn, and Facebook, and this conversation is for informational purposes only and does not create an attorney-client relationship. So please comment your questions below or email us at info@chug.com and we'll be happy to help you out. Once again, thank you for joining me today, Min. We have a lot to dig into as apparently there are some rather large changes at the Department of Labor, which might affect how foreign national workers apply for their U.S. green cards.
Right, that's right, Ariana. I suppose it's not new news per se, as these changes at Department of Labor have been in the pipeline for some time now. But actually, starting today, June 1st, Department of Labor has officially migrated its PERM labor certification portal from their legacy PERM module before on their website to this newly revamped and redone flag portal.
Flag, can you talk a little bit about that? What is flag and does that stand for something?
Yeah, flag stands for Foreign Labor Application Gateway. It's just a fancy a fancy phrase for the agency's platform that currently handles LCA filings for H-1B cases, for instance, as well as other immigration matters like an H-2A or H-2B application. Until now, the platform was primarily reserved for temporary work visa cases like an H-1B or an H-2B. But now, effective today, Department of Labor wants U.S. employers to electronically file permanent labor certification application on the same flag platform for the foreign workers that they employ.
So that sounds like a rather big deal, Min. Does all of this news impact all foreigners looking to secure their approved U.S. green cards? How many people are we talking about here?
Well, the number is rather large. We're probably talking about thousands, if not tens of thousands, of foreign nationals here present in the United States. But I do want to be clear that it doesn't impact every foreigner looking to apply for one's U.S. permanent residency. As the audience might already be aware, there are different avenues that one can pursue in looking to secure his or her green card. I suppose some of the more common ones are if there's a qualifying U.S. relative, let's say a U.S. citizen wants to petition for his or her spouse, a U.S. green card holder, likewise for parents, children, spouses. So that's probably the more common scenario, a family-based green card petition. Other avenues are if there's a foreign national who has some investment sum that they're looking to invest into the U.S. economy, opening a business. The immigration law as it exists right now provides a pathway for that person to also petition similarly for his or her green card based upon that qualifying investor. That's typically called the immigrant investor visa. And just speaking from the context of a employment-based green card as well, just because that a U.S. employer is looking to sponsor a permanent residency application for a foreign national worker, it doesn't necessarily mean that they have to go through the PERM labor certification process. There are certain options that are exempt from the labor certification. I suppose some of the more common avenues to that are something called the EB1 green card. EB1 is typically reserved for individuals who are classified as possessing extraordinary ability in specific industries such as science and business, for example, as well as individuals who might qualify for the national interest waiver. The national interest waiver is an EB2 green card but it also likewise skips over the labor certification process. So, securing the green card, there are a variety of options, but still, despite pockets of people having different eligibility criteria, for the most part, a perm labor certification filing with the DOL is probably the most common um, you know um, scenario that might apply for individuals looking to make the U.S. their permanent residence. And for those individuals who kind of fit within those specifications, that employer does have to petition for the green card by undergoing the perm process.
That's all really enlightening, Min. So let's talk about these changes to the PERM application. What are they, and are we talking about a brand new form and process altogether that companies and foreign workers need to be aware of? Can you dive into that a little bit?
Yeah, absolutely. I suppose that's a tricky question because is it a brand new form? Well, I mean, there's a part of me that wants to say both yes and no to that. It is a new form. It's a new addition to the form. The form hasn't been updated since the mid 2000s, so it's a long time coming. And obviously the businesses have changed and how businesses operate have changed since then. These new changes are indeed welcome, and they're intended to in a way streamline the overall labor certification process. But it's not that the Department of Labor has scrapped the earlier edition altogether and created something brand new. There's still a resemblance to what the labor certification form looked like before. And I can say that probably most of the changes are stylistic in how the Department of Labor is now phrasing certain questions to garner and solicit certain information from U.S. employers, or perhaps the attorney who might be preparing the PERM case for that employer and that international worker. You have to, I suppose, the audience should keep in mind that there are specific rules and regulations that the Labor Department must follow in preparing a PERM, labor certification form. So dramatic wholesale changes, I don't think necessarily would apply, but certainly changes do exist. Now, going to your question about what are some of the more important changes that the audience should be aware of based upon this new edition of the form, I suppose, the things that come to mind and kind of looking over the form just earlier this week, before it's launched, effective today, is that the form really kind of breaks down the whereabouts of where a foreign national, beneficiary is currently working from. Just generally speaking, if a person is not situated directly at an employer facility, let's say, where employer headquarters is and they operate their business from, and they happen to travel, the Department of Labor wants to be aware of that. I suppose, such individuals, they might be classified as roving employees or telecommuting employees, or individuals, perhaps the nature of the job requires them to be working from different employer sites. So they have multiple, work sites that they need to be disclosed as part of the PERM form. The earlier addition to the ETA 9089 form, the PERM application, it didn't really provide specific, fields where those questions were asked, where a sponsoring employer can disclose those details, very precisely. I suppose just over many years of trial and error and practice, those companies and those attorneys who might have prepared those labor certification forms before, we just kind of dumped all that information in the free text field that's offered in the 9089 form. Now, this new version of the form does not allow for that. There are very specific targeted questions that directly ask the preparer of the form, is this a roving employee? Is it a telecommuting employee? Are there multiple work sites? So indeed, an extra measure of care and caution need to be applied in making sure that the nature of the job, if it does allow someone to work from home, that does need to be disclosed, and it needs to be disclosed and answered in the right appropriate context in the field that the form allows. Some of the other changes that I personally noticed in kind of looking over the final version of the form is that it does require a little bit more nuance and separation in kind of detailing out how the foreign national beneficiary qualifies for the for the offered position for the permanent role at the petitioning employer. Before, kind of similar to what I mentioned before, there were open text, free text that allowed an attorney like myself to kind of dump everything that is needed to communicate how the foreign national worker applies, how he or she might qualify for this position into one specific space. Now that space is kind of separated into multiple spaces, and that care needs to be exercised in making sure that the correct information is revealed and answered according to those specific questions. Other distinctions to be aware of is the need now to affirmatively disclose the business necessity justification for a specific position's job requirements. I suppose depending upon how sophisticated the audience is, a lot of times, and especially if just generally speaking, for EB2 perm positions that might require a master's degree for entry into the role or a bachelor's degree and 5 years of experience, and that kind of bumps the green card petition filing ultimately to an EB2 category. Depending upon the nature of the position and what industry it's in, a lot of those times, such job requirements that justify an EB2 filing exceed the normal SVP. SVP stands for specific vocational preparation. And if those job requirements do exceed the SVP, it is required, it is mandatory for a petitioning employer to justify the reasons why its normal job requirements for this position that they want to sponsor for labor certification exceed the normal industry-wide job requirements for similar positions within the field. So there has to be, care, that's applied in kind of answering those questions. A lot of times, historically, those questions were answered at the audit stage. If a labor certification was selected by Department of Labor for a PERM audit, then the preparer of the application can then affirmatively supply those answers for business necessity justification as part of the audit response. Now it appears that Labor Department wants to receive that information in advance for every single labor certification PERM that's submitted to the government agency. So that's a rather dramatic change, and that's something that the audience should be aware of if it turns out that you are sponsoring a PERM application for one of your foreign national workers, and if the position's job requirements exceed the normal SVP for that role in the typical industry, then absolutely be prepared to provide those justification reasons why the nature of your business justifies those elevated job requirements. And then finally, perhaps I can add that just procedurally speaking, there are some distinctions involved. Obviously, the migration to the flag platform, as well as the ability to perhaps pre-populate already entered data. As part of every PERM application, there has to be a preliminary prevailing wage determination that's issued by the Department of Labor that kind of outlines what the requisite prevailing wage is for that role, depending upon the job duties and the job requirements for that position. So before, practitioners and preparers of PERM applications, they just kind of enter that data by hand by typing that information into the PERM portal. But now there's a way to connect an earlier prevailing wage that's issued. So that's welcome change. It requires less work, and it invites an opportunity for less human error instead of just kind of populating that information in by hand.
This is all really helpful information for our listeners, Min. I appreciate you diving into that. So you said before that there aren't too many changes to the new PERM form, but from everything you've listed out, I actually don't know if I can agree with you there. So let's get to the question that's on everyone's minds. Why should our listeners care about this? Why should companies, big, small, mid-sized, and the foreign national workers whom they employ care about this? I guess what I'm asking is, what's the payoff in all of this, and why is the DOL making these changes now? And does it impact either US employers or the foreign workers at those companies?
Right, right. That's a really good question, and I suppose I can try to answer that in two parts. Why should employers and why should foreign national workers being sponsored for labor certification care? The first thing that comes to mind is are the processing times involved, and anyone who might have gone through the labor certification process, been the beneficiary of a PERM filing, they can attest to this. A perm takes a really long time. We're talking about months, perhaps even years before the finish line is reached, and that can be frustrating, obviously, for a petitioning company that wants to sponsor a green card for a high net worth, valuable employee that needs such sponsorship, as well as the foreign national worker. I mean, it directly impacts him or her. They're probably here already working for that petitioning sponsor based upon a temporary work visa. As the audience might know, temporary work visas are indeed that. They're just temporary. They're short-term work visas. They don't provide work authorization for years on end, indefinitely. And there's a certain point in time where that work authorization stops without the option or the possibility to renew that and further extend one's visa status. So time is of the essence. But for a variety of reasons, whether it be lack of government funding, the Department of Labor, they freely admit they're overworked. They don't have enough staff to process the volume, the huge spike in volume in labor certification filings that have happened in recent years. Just for illustration's sake, perms at times, many years back, they were adjudicated perhaps maybe in 4 months, 5 months max. Now those adjudication processing times are closer to 9 months and beyond, just for an initial analyst review. And if it happens that the application is selected for an audit, because the audit process is not going anywhere, it's still there despite the migration of the perm form to now flag. Audit reviews by the Labor Department. I mean, we can expect to add an additional 1 calendar year on top of the 9 month processing time frame. So, why should employers care? Why should employees care? It is intended to streamline the adjudication process a bit. Before, as I mentioned, there was a lot of free text that practitioners like myself relied on to make sure that the Labor Department certifying officer had everything that he or she needed in order to render a favorable decision for a client for a perm filing. Now, because there are more targeted questions, I would hope that a reviewing officer at the Labor Department can quickly just go back and forth, knowing that everything that needs to be there is there because these questions are asked, are there on the form to ask for these issues that need to be, affirmatively addressed in order to render a perm approval, and they no longer have to, spend so much time in kind of reading over the pages and pages of free text that we traditionally relied on before. So we were hoping for shorter processing times. The Labor Department is on record saying that they really wanted to kind of expedite the launch of this new edition of the PERM form because they want to streamline the application process. So hopefully, streamline means a reduction in processing delays. So no longer will companies and the foreign national workers for the beneficiaries of these applications, they no longer have to wait 9, 10, 11 months for a decision on a perm case. And then perhaps secondly to that, and this goes without saying, I think it was kind of brought up earlier, a perm is at times critical in order for someone to start the process of securing one's green card. A lot of times it's the first step. If someone doesn't fall within the exemption where they can skip over the labor certification process, let's say they're not a multinational manager or someone who might possess extraordinary ability according to those definitions by the immigration rules, they have to go through the labor certification process. And a lot of times they're here based upon a short-term work visa. And just using the common scenario of someone here in H-1B status, a lot of times the H-1B work visa is issued for 6 years, and it's a 6-year work visa, unless someone qualifies for certain exceptions where they might have a specific green card case that's filed and in the queue, and then they can potentially extend that work visa beyond 6 years. But if the perm is, delayed, it started late, it's stuck within the 9-month government processing time, and there really is not a lot of headway that's made in kind of advancing the green card process to a certain point, then there might be a really, a real chance for the person to lose the ability to work, and they might have to leave the country and kind of finish the green card process while they're overseas, which introduces a whole set of unique circumstances and further delays because then we're talking about a different government agency, unfortunately, because they're no longer here in the United States to complete that green card for them. So it's a lot of variables, but I suppose that all these are real reasons why perhaps introducing a new form that might make it a little bit more streamlined to shorten the processing times, and that employers can be aware that these changes are in the end ultimately intended to shorten the delays and how soon one can apply for one's green card. Those are welcome changes indeed. And I suppose finally, if I can add to all those things, you know, um, a labor certification, like in the end, it's an attestation-based process. And what I mean by that is the Department of Labor is at times rather unforgiving in terms of adjudicating and reviewing a submitted perm. And that's important to know because unless an application is audited, there really is no method to supplement one's answers in completing the form to help clarify and explain to the government what you're trying to file. Just in recent years, there's been plenty of administrative court proceedings that have held that in the interest of government efficiency and streamlining the labor certification process, issues such as giving the preparer of the perm the option to correct innocent typographic mistakes, for example, will not be granted. And you have to couple this policy reason with of promoting efficiency over accuracy and arguably due process. It makes the world of preparing a perm application rather unforgiving, meaning that whoever is preparing your perm application better know what he or she is doing, because otherwise, if a mistake is made, it won't be discovered for months or perhaps even years from when the application was first started, because as I mentioned, it takes the government that long, unfortunately, to review these applications. Thus, this combination of lengthy processing delays at Department of Labor, as well as the system being attestation based, it creates a situation where the perm needs to be prepared spot on. It needs to be, accurate. It needs to kind of check off all the boxes that Labor Department, reviewing officers look for in order to be in order for that application to be deemed approvable on its face. Because everything that needs to be said it must be said within those four corners of the perm form, because otherwise, the Department of Labor is not going to give you a chance to further explain because it's attestation based.
That's sage advisement. Thank you for reminding our audience how essential it is to retain competent legal counsel in preparing and submitting the new edition of the PERM application. I can't imagine such consequences of seeing an application that's prepared for an H-1B worker, for instance, being denied months or even years after when the application process first started. That's got to be devastating for both the company employing the individual as well as the foreign worker themselves. And with the new form being what it is, with the new sets of questions pertaining to issues like business necessity, multiple work locations, etc., I can absolutely foresee employers being stuck on how to complete the new PERM application form since there's no precedent to work off of. It's a brand new form.
Yeah, yeah. I mean, I couldn't have said it better myself, Ariana. You're absolutely correct there. That both employers and foreign national workers looking to undergo the labor certification process, they absolutely need to retain competent counsel whom they trust. Who they know will know the ins and outs of the brand new perm form.
So considering the time we have left, Min, I think we have time for one more question from the audience. So let's see what we have from our audience. What about this question, Min? Somebody is asking, I'm the owner of a company and we file a handful of PERM cases for our foreign workers every year. My company uses 2 or 3 different law firms to handle our PERM cases. Is this going to be a problem with the PERM now being on flag?
Right. That's a really good question, and perhaps maybe as recent as a week ago, my answer would probably have been different, but now it appears to be less of an issue. I mean, what I mean by that is leading up to today's launch, obviously, Department of Labor, specifically their Office of Foreign Labor Certification Division, that handles the adjudication of these PERM labor certification filings, they held a couple of informational sessions and webinars to help stakeholders, whether it be companies petitioning for a perm or perhaps law firms and lawyers like myself, who are now being introduced to this brand new form. The Labor Department held these sessions, instructional sessions, to kind of help us navigate how to answer specific questions because, yeah, I mean, a large portion of the perm is different. Um, and I suppose one question that was asked and some clarification was brought into during those sessions is that um, there wasn't an option to connect a prevailing wage determination from earlier to a perm application that one is preparing if you weren't the one who prepared the prevailing wage before. So, a lot of times because of these delays involved, an employer might have already started the prevailing wage process. The prevailing wage typically is the first thing that must be done in order to kind of launch a perm, in order for that perm to be started. And there's a way to perhaps reuse earlier issued prevailing wages. So, there are different variables here. But for the most part, prevailing wages, could have been done earlier. And if the party handling that, I mean, if it's the same attorney handling both the prevailing wage as well as the eventual perm application, this is a non-issue. But there are instances where, if a company wants to, just for efficiency reasons, just handle the prevailing wages themselves, or perhaps they might have, retained 2 or 3 or 4 different law firms to handle their group of perm cases, as it appears, the person asking this question. If that's the case, and if let's say they might have asked, law firm XYZ to handle a bunch of perms last year, and there's the option to perhaps reuse a prevailing wage that was associated with that first batch of perms, but now they want to, ask law firm ABC to handle this new set of perms. Well, law firm ABC, because they didn't handle the prevailing wage for the first set, there was no way to retrieve that required prevailing wage determination before. So, I suppose that was definitely an issue, and you could tell that's something that the Labor Department was not really mindful of when it kind of precluded that option and prevented that option of retrieving a prevailing wage that might have been issued by a different party who prepared that prevailing wage earlier. With the delay in the launch, it was scheduled for last month, but it was delayed until today. The Labor Department thankfully kind of fixed those, little technicalities, those inconsistencies. So, it now appears that, let's say a company might use different law firms, different attorneys. There is a way to kind of look back to a prevailing wage that might have been prepared by a different law firm, a different party altogether, and still connect that prevailing wage that was issued earlier to the perm that you're preparing now. So it seems like there's at least some kind of resolution here. But I suppose this is just a good reminder, and it really underscores how quickly this overall landscape is changing, and I mean, in an unsettling kind of way, how Department of Labor is sort of changing the rules midstream before the new module was properly tested and vetted for any inconsistencies or bugs. I don't want to say that the agency is kind of making or bending the rules as we go along, but if someone were to come to that conclusion, I can't say they're entirely off base.
Wow. So on that disturbing note, I think that's all we have time for today. I hope this LinkedIn live session was as eye-opening for our audience as it was for me. Most, if not all the time, temporary workers come to the US on a temporary work visa with long-term plans of getting their US green card and making the US their permanent home. So a PERM labor certification application is the first step to achieve this. So it has to be prepared correctly with minimal red flags that might further delay the green card process. So having trusted, competent legal counsel does go a long way in securing this assurance, especially given the changes to the form and the platform that it sits in today. So thank you so much, Min, for your insights, your time, and for joining us today.
It's my pleasure, Arianna. Thank you for having me.
Thank you, Min. So this does bring us to the end of our conversation. Thank you everyone for joining us today. If this video was helpful, please make sure to give it a like. And to stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. And please turn on the notifications so you can be notified of our next upload. If you have any questions or suggestions, please send us an email at info@chuk.com. And don't forget to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care.